Yes, Your Honor.
It looks like my AA was corresponding with you by email with regard to the establishment of child support base. Could you please update me, like where we're at and what's needed from me at this point?
Absolutely, Your Honor. I will note for the court's record that both parties were totally compliant in getting the information that we needed. Part of the difficulty in this case, and is something that you mentioned in the last hearing, is that the children were kind of moving around without the court's order. And as such, it was really difficult for DCF to maintain a consistent case number with the appropriate children listed with the appropriate parent. So each time children move back and forth, that messes up the way that our cases are set up. So it took quite some time to get that part worked out, Your Honor. So I apologize for the delay, but I will note that both parties have been completely compliant, have totally been calling in and to give information. So, and I apologize for the delay. I did run a child support worksheet on September 5th of 2024. That came out to Ms. Sharp paying $506 per month. I used an average of 3 pay stubs that were provided by, I'm going to mess up last names. I'm sorry. Can I use first names?
Yeah.
Kyle. So I used an average of 3 pay stubs from Kyle, and I used an average of 3 pay stubs from Malia. Kyle's income came out to $2,866 per month, and Malia's income average of 3 pay stubs was $2,075 per month. Kyle is carrying health insurance coverage through the state of Kansas on the children. There is no cost for that. And I gave Kyle the ability to claim the children for tax purposes with a $111 adjustment given monthly to Malia. So my request today would be that the court set support at $506 per month, payable by Malia, effective 5/1 of 2024, which was the date indicated in the order that you previously signed in June for the effective date of support. That Kyle continue to carry health insurance on the minor children and claim the children for tax purposes.
Okay. Do we have any objections to that or a request to seek independent counsel?
I actually do, Your Honor.
Okay.
So when we first did this, it was from November of 2023 when our divorce was final. And we had said that Malia had 1 child for 4 months. 4 months. And then at March, I had all 3 children. And then from April on, I had 2 children and she had none. That was in the last court. That's exactly what the order was that you put, that she was supposed to pay back child support as well.
Well, I can't order back child support for a placement that you all did without notification to the court and a motion to modify child support. I can't go back and resurrect what people have been doing for 2 or 3 years and then decide who owes what when there's already an existing order in effect.
I'm confused because I changed it from a child support to a custody thing in that last one. On the last court date in May. It wasn't over child support. We withdrew that one and put in another case for custody because the custody that was set was she had Linnea and I had the other 2.
Well, this does go back to May, but it doesn't go back to 2023.
When we got divorced in November. So I've carried the kids for a year now by myself with no one to help. She has
because you are self-represented. I told you numerous times to seek an attorney or get with DCF or a contract attorney to file a motion and submit a proposed worksheet. I can't work as an attorney and do all that for you. So if you want
I did everything.
It would have been worth it for you to hire an attorney to do the calculation solely for child support, to bring it in front of the court, give her notice, and request it and get it ordered. Now, Ms. Soretti, is there any other arrearage that is owed by either party other than her obligation that is dated back to May 1 of 24 when the formal motion and hearing occurred.
No, Your Honor, the original divorce decree that was filed in November of 2023 did not have child support ordered. So there is no arrearage that could have been calculated prior to that motion that was filed in April of this year. So Mr. Smith filed a motion in April of this year to modify the journal entry, include change in custody and child support. Once that motion was filed, I think that's where the May 1st effective date came from, because he filed a motion for child support in
Right.
April, and the
Right.
statute requires that support be set 1 month following the month of the filing of the motion. So that was our effective date, May 1st.
The only thing that I could have done differently, and as I recall, this got drug out several times for me to finalize. The only thing I could have done different is just not giving you a divorce at all, and said, I'm not making custody decisions. I'm not divorcing you. I'm not doing anything because you don't have child support.
Honestly, Your Honor, I don't understand why that wasn't set in the first place. I'm just going to be honest.
Because it was never computed and never submitted and never up.
I tried. So you gave me a gentleman's number from Topeka from Child Support Services, and I tried to call them and they didn't. And then we did all the paperwork once before. In November, we did this. I've done this multiple times. And they said it would take so long. And then they said it was because the custody was all messed up because of the way we did it. So that's why I went back to court and made sure that there was a full-fledged custody set in place. That way no one could question.
And that's where I'm granting your child support file, period. You have no proposed child support worksheets filed for approval by the court in this court file. So I don't know what you're talking about, what you did or didn't do. But you had plenty of opportunity, and I cannot do the work for you.
You didn't. I didn't ever ask anyone to do the work for me. That's the whole thing, Your Honor.
Well, you could have
asked somebody to help me. I haven't had any help from the state of Kansas or from Malia Sharp in over a year, and I've raised all 3 of my kids by myself, and yet I sit here and you treat me like this.
I'm not treating you any particular way.
You have the whole time, Your Honor.
No, I haven't. You expect me to be your attorney and your judge, and you do things outside of the presence of the court and change things constantly without getting the approval of the court. And then you want me to go back and retroactively do things that suit you, and I'm not going to do it.
Your Honor, that's fine.
Okay, so you have a judgment for arrearage that is owed in the amount of $506 back to May 1st, and $506 from this point forward. And you have an attorney that will do an income withholding order to make sure that you get your money. You also have a way that will be tracked through the state to make sure your arrearages are noted, and that every month thereafter, the child support becomes a judgment so that you can collect. You have an attorney that will do any collection efforts necessary if a job changes. You have to notify the court if there are any custody changes whatsoever, because the guidelines now take into consideration the amount of time that any parent has with a particular child. Normally, the court's not in the business of ever dividing siblings, but you have to get permission from the court to do custody modifications, and then Ms. Soretti will be notified and make any appropriate child support modifications that need done. Okay?
That's fine. I'll just make sure that in my next motion, they know that she does not follow any visitation orders. Not one.
Yeah.
Has not kept them overnight and didn't even see them in the month of September.
Okay, here's the deal. This has always been the case. I don't care what anybody's told you for the last
I know no one's told me anything.
Years, is that I cannot force parents to exercise their visitation.
I
I
understand.
force them to pay child support. She isn't going to get any credit for time, like a shared custodial arrangement, if she's not exercising it. But I cannot force her to exercise visitation of a child.
No, I understand that, Your Honor. I understand a deadbeat is a deadbeat. That's all there is to it. Male, female, it doesn't matter. When they owe and they refuse to pay and they refuse to see their kids because of a boyfriend or a girlfriend, it's on them, not on you. I understand that.
All right. Well, hopefully this will get you all back on track and you know what your obligations are and that you will either
My obligations have never changed. My kids.
exercise them or file a motion to get before the court or consult with an attorney for assistance. If you need to do a contempt citation or something, because that does get a little complicated. All right, Ms. Soretti, do you need anything else from?
Your Honor, I don't believe I need anything else from you. I do believe that Ms. Sharp may have unmuted at one point. I don't know if she has anything to add or if the court would inquire.
No.
I do not, Your Honor.
All right, thank you.
Thank you.
All right.
I guess I do have one other question. Given that there is an arrearage, how would you like the IWO to issue?
Oh,
We will obviously issue for 506 current,
All right.
but what would the arrears?
So May, June, July, August, September, October, November, December. 8 times or
There will be nearly $4,000 arrearage if there's about 8 months. So I just would like to know how much you think we could
Right.
include on the IWO.
no, I'm trying to work on it. 4,048. Well, you know, most of the time it's $50 to $100 that is tacked on, and then of course he can collect any other way that he wishes by garnishing wages or however he wishes to collect on an actual judgment. But I don't know what is the standard for you all now? 100, 150? What are you doing in child support enforcement?
30%, which in this case comes out to an extra $151 per month. But I do often bring this to the court's attention to inquire as to whether or not that's feasible and doable if somebody is paying that much per month.
So I'm sorry, what'd you say, 151?
Yes, 30% comes out to 151.
And I said, what did I say, 4,084? Is that right? Something like that.
Yeah, it was nearly that.
Divided by
1,048, Your Honor.
4,008?
48.
48, okay. I'm sorry, I transposed that.
That's okay.
Okay.
It would take a little over 2 years to pay off the arrearage at 151 a month.
Trying to figure out, I can't clear my
Sorry, I thought so, Your Honor.
calculator on my phone.
52, 56.
Okay. Well, I think with him, given the history here, probably you need to pay it off sooner rather than later. I am going to approve the 151 to be added to the 506 for a total of 657, and then there's the, I think, 3% fee.
No fee for DCF collection.
No fee. Okay, good.
Okay.
So that's what the income withholding order will be approved for.
Okay.
Obviously, that can be paid off anytime sooner, but at a minimum, it needs to be paid off at that monthly rate. Thank you for letting me know and reminding me of that.
Yes, thank you, Judge. And I will note, just like you said, if Ms. Sharp, if you wanted to make a lump sum payment to pay down the arrears at any point in time, we would then amend our IWO once the arrears were paid in full, just to hold current support.
Okay, thank you.